She hasn't held a real job since she dropped out of that MBA program. That is what my brother said, standing in front of a superior court judge in Halifax, Nova Scotia. His voice smooth and rehearsed, like he had been practicing in front of a mirror for weeks. She's been living off our mother's generosity for years, and now that our mother is gone, she wants to take what isn't hers. I did not move. I did not look at him. I kept my hands flat on the table in front of me, fingers slightly spread, the way you learn to hold yourself when you are trained not to react. The courtroom smelled like recycled air and old carpet. The kind of room that has absorbed too many arguments and not enough resolutions. My name is Claire Beaumont. I am 32 years old. And the man who just told a judge I was a parasite is the same man I watched grow up, the same man whose university application I edited at 2 a.m. when I was 19 and he was 17 and convinced he was going to fail. He does not know what is sitting in my lawyer's bag right now. He does not know. And that is the only thing keeping my expression neutral. Have you ever had someone look directly at you and describe a person you have never been? Someone who took the silence you kept out of duty and handed it back to you as evidence of failure? Leave a comment below. I want to know if you have ever felt that kind of erasure from someone who was supposed to know you better than anyone. My brother's name is Daniel. He is 30 years old, and he has spent most of his adult life assuming that because he was loud, he was right. He runs a real estate brokerage in Dartmouth that our mother helped him fund with a $180,000 loan when he was 26. A loan he has never fully repaid. A loan he stopped mentioning at family dinners the moment he bought his second investment property. Our mother, Margaret Beaumont, passed away 14 months ago from a cardiac condition she had managed for almost a decade. She was 61 years old. She was the kind of woman who kept her finances in a leather binder and her opinions to herself, who drove the same Subaru for 11 years and somehow always knew when you needed money before you asked. She left behind a modest estate, a house in Dartmouth worth approximately $520,000, a registered retirement savings account, and a small investment portfolio she had built over 30 years of working as a hospital administrator. She also left behind a will with a clause that Daniel had decided to use as a weapon. The clause stated that any beneficiary who could not demonstrate active financial contribution to the family in the 5 years preceding her death would receive a reduced share. Daniel's lawyer had argued, with great confidence, and a very expensive suit, that I did not qualify. That I had spent the last several years floating between what he called vague consulting work and extended absences that no one in the family could account for. He had hired an investigator. The investigator had found my LinkedIn profile, which had not been updated in 6 years. A rented apartment in Ottawa I had listed as my address for tax purposes, and very little else. He thought that was enough. He had no idea what was in the sealed letter sitting inside my lawyer's briefcase. I had come back to Halifax only twice in the past 4 years. Once for my mother's diagnosis follow-up. Once for the funeral. Each time, Daniel had made a point of asking me, in front of extended family, what exactly I did for work. Each time, I had given him the same answer. Federal policy work, contract-based. I'm not able to go into detail. And each time, he had laughed in a way that was designed to sound casual but land like a verdict. Federal policy, he said at the reception after the funeral, holding a plate of squares from the church hall. That's what we're calling it now. My aunt nodded along. My cousin smiled into her tea. I looked at the frost on the window and thought about the briefing I had to get back to. When the estate dispute formally began, I was not surprised. I had watched Daniel rewrite the family narrative for years, slowly and methodically, the way someone tiles a floor. One conversation at a time, one phone call at a time, building a version of Claire Beaumont that was convenient for his argument. In his version, I had abandoned our mother. I had contributed nothing. I had shown up only when there was something to gain. The reality was that I had been sending money home since I was 24 years old. Not through wire transfers in my name, not through anything traceable to me directly, because my work required a level of discretion that does not accommodate visible financial trails. I had arranged for my mother's private cardiac monitoring service, the one that sent a nurse to her home twice a week for 3 years. I had covered the gap in her extended health coverage the year the provincial plan changed, and her medication costs jumped by $400 a month. When the furnace in the Dartmouth house failed in February 3 years ago, and Daniel told her he was too stretched that month to help, the repair company received payment through a numbered account I maintained for exactly these purposes. My mother knew. She was the only one who knew, because I had told her, carefully, in the way I had learned to communicate things that could not be written down. She had held my hand at the kitchen table, and told me she understood. She had also told me she had made arrangements to protect my interests when she was gone. I trusted her. I trusted the lawyer she had worked with for 20 years. What I had not anticipated was Daniel getting to that lawyer's office 3 days after the funeral with a copy of the employment clause and an interpretation that suited him perfectly. I watched him from across the courtroom now. He was wearing a charcoal blazer, and a confidence that had not yet been tested today. His lawyer, a woman named Patricia Greer, had the practiced energy of someone who had won enough cases in small claims to believe that volume equals competence. She had built her argument on the investigator's report, on the thin, visible outline of my life, and on the assumption that invisible means absent. Patricia Greer approached the witness stand where I was seated and looked at me the way people look at something they expect to fold. "Mrs. Beaumont," she said, "can you provide this court with any documentation of employment income in the last 5 years? A T4, a notice of assessment, a contract, anything that would indicate you have been financially active in any conventional sense?" I looked at her. I kept my voice at the same temperature I use in rooms where the wrong inflection can derail a 6-month operation. "My work is contract-based and subject to confidentiality agreements that restrict what I can disclose in a public proceeding," I said. "My tax filings exist. The relevant authorities have access to them. The fact that they are not accessible through a standard background search is not evidence of absence. It is evidence of classification." Patricia smiled. It was the smile of someone who had been given a gift. "Classification," she repeated, turning slightly toward the judge, as if sharing a private joke. "Miss Beaumont, we are in a probate dispute in Halifax, not a spy novel. Could you at least tell the court the name of the organization you claim to have been working for?" "I work in federal security analysis," I said, "under contract arrangements that I am not at liberty to name in an open proceeding." Daniel leaned over to Patricia and whispered something. She nodded. "Your Honor," Patricia said, "I would like to call Mr. Daniel Beaumont to the stand to speak to the nature of the family relationship and his observations of the respondent's lifestyle and conduct over the relevant period." My brother walked to the witness stand with the easy stride of a man who has never once considered that he might be wrong. He settled into the chair, adjusted his blazer, and looked at the judge with the expression he reserves for people he wants to impress. "Daniel," Patricia began, "can you describe your sister's involvement in the family in the years since she moved to Ottawa?" "Minimal," he said. The word was designed to land like a door closing. "She called on birthdays when she remembered. She missed our mother's 61st birthday entirely. Said she was traveling for work but couldn't say where. She wasn't at Christmas 2 years running." He paused for effect. "Our mother covered for her every time. Made excuses for her. That was Mom's way. She was generous to people who didn't deserve it." "And financially?" Patricia prompted. "Our mother never mentioned receiving any financial support from Claire. Not once. I handled the household accounts when Mom got sick. I paid for the grocery deliveries. I drove her to her cardiology appointments. Claire sans ta carte." I heard something shift in the room. The judge, a man named Justice Thibeault, was writing something down. The court clerk adjusted her posture. I looked at the far wall and thought about a conversation my mother and I had in her kitchen 2 years ago, when she pressed a folded piece of paper into my hand and said, quietly, that she had spoken to her lawyer about the arrangement, and that everything was in order. Daniel was still talking. He had moved on to a detailed account of a Christmas 5 years ago when I had arrived late and left early, which he was presenting as evidence of character. Patricia nodded with the careful attention of someone being paid by the hour. "And is it fair to say," Patricia asked, "that in your assessment, Claire's presence in this family has been more of an absence, and that the employment clause in your mother's will was specifically designed to capture exactly this situation?" "Yes," Daniel said. "I think Mom knew. I think she saw what Claire was doing and tried to build in a protection. I think Claire is here today because the money is the only thing that ever brought her back." I let that sit for a moment. Then my lawyer, a man named Robert Faulkner, stood up. Robert Faulkner was not from Halifax. He was from Ottawa, and he had been referred to me through channels that do not appear in the Law Society directory. He was 54 years old, and wore the kind of quiet that has nothing to prove. He had driven down from Ottawa 2 days ago, and had been in my mother's lawyer's office for most of yesterday afternoon. He did not perform. He simply opened his briefcase. "Your Honor," Robert said, "I'd like to address the matter of Miss Beaumont's employment and financial activity directly. The respondent has been subject to a confidentiality framework that has, until this proceeding, prevented her from disclosing the nature of her work. Given the accusations made in this proceeding, her federal employer has granted a limited disclosure authorization under the Security of Information Act." He lifted a brown envelope from his case. It was sealed. The return address was a government office in Ottawa. "I am submitting a verified statement of employment and financial contribution, pre-authorized for judicial review." Patricia Greer's smile disappeared. "Your Honor," she said immediately, "this is a probate matter. Whatever federal document is being waved around here has no relevance to." "It has direct relevance," Robert said, not raising his voice, "given that the core claim in the plaintiff's case is that the respondent has not been financially active or employed in the relevant period. This document addresses that claim precisely." Justice Thibeault looked at the envelope. He was in his late 50s, The kind of judge who has seen enough procedural theater to recognize when something genuine has entered the room. He looked at Robert. He looked at me. His eyes paused on the small enamel pin I wore on my lapel. It was a maple leaf set inside a geometric frame. The kind of design that would mean nothing to most people in this room. It was the service recognition insignia of the communications security establishment. Justice Thibeault had spent 12 years as a Crown prosecutor before the bench, with a security clearance that overlapped significantly with federal intelligence work. He recognized the insignia. I saw it in the way his expression changed. Not dramatically. Just a small recalibration, the way a compass settles when it finds north. "I'll review the document in chambers," he said. His voice had shifted slightly. "We'll take a 15-minute recess." Daniel turned to Patricia and said something in a low voice. She was already pulling documents from her folder, reorganizing, the way people do when they sense the ground moving under them. I stayed in my seat. I did not look at my brother. I thought about a morning in 2019, when I had been in a windowless office in Ottawa, on hour 14, of a signals intercept analysis, and my mother had called to tell me that Daniel needed money for a legal issue, with a property deal that had gone sideways. She was going to lend it to him. I had told her it was her money and her choice. 3 weeks later, I had quietly transferred $22,000 into the buffer account I maintained for family support, to cover what I knew she would give him and couldn't afford to lose. He never knew where that money came from. She told him it was from savings. He sat in that courtroom now and called me absent. When Justice Thibeault returned, he walked to the bench with a different quality of attention. He set the document down. He picked up his pen, then set it back down. He looked at Patricia Greer, then at my brother, and then, for a long moment, at me. "Counsel," he said to Patricia, "I need to inform this court of what I have reviewed." Patricia straightened. "Your Honor, if the document is classified, it should not be." "It has been authorized for limited judicial disclosure," Justice Thibeault said. His tone was not unkind, but it left no room. "The authorization was issued at the departmental level and is consistent with federal disclosure protocols." He paused. "The document before me is a verified statement of employment from the Communications Security Establishment of Canada, one of this country's primary signals intelligence agencies. It confirms that Claire Beaumont has been employed as a senior intelligence analyst under a protected identity framework for the past 7 years. The room changed. It did not erupt. It compressed, the way air does before something breaks. Furthermore, Justice Thibeault continued, attached to this statement is a financial summary, also authorized for judicial review, detailing a series of directed financial contributions made to the Beaumont family estate through protected channels over the past 5 years. These contributions include payments to a private cardiac monitoring service, a pharmaceutical gap coverage fund, and a property maintenance service, all directed to Margaret Beaumont's residence. He looked up. The total documented figure is $94,700. Daniel had gone completely still. Patricia Greer was looking at her notes with the expression of someone trying to locate an exit. "The employment clause in the late Margaret Beaumont's will," Justice Thibeault said, "requires demonstration of active financial contribution to the family. The evidence before me documents precisely that contribution, made consistently and deliberately, over the relevant period." He looked at Daniel. "Mr. Beaumont, it appears your sister did not send a card. She sent a cardiac nurse, twice a week, for 3 years. I heard Daniel exhale. It was not a sigh. It was the sound of a structure failing. "Your Honor," Patricia began. "Miss Greer," Justice Thibeault said, "I would strongly advise you to consult with your client before we proceed any further." There was a pause of approximately 40 seconds. I counted them. "It is a habit from work." Patricia leaned over to Daniel, and I watched his face move through several expressions he did not have words for. The smugness was gone. In its place was something smaller and more honest. Something close to the look he had when he was 17, and had just realized he had studied the wrong chapters for an exam. He had been so certain. He had built such a clean, complete version of me in this courtroom. The absent sister. The drifter. The woman who took and never gave. He had stood in that witness box and described me with the confidence of a man who had never once considered that his information might be incomplete. It had not occurred to him that the silence I kept was not emptiness, that the blank spaces in my visible record were not gaps. They were walls, built carefully, for reasons that had nothing to do with him. Patricia stood. "Your Honor, the plaintiff wishes to withdraw the challenge to the employment clause." "Noted," said Justice Thibeault. "The challenge is dismissed. The respondent's full inheritance share is upheld." He set down his pen. "I am also awarding costs to the respondent in the amount of $18,500, to be paid from the plaintiff's share of the estate, in recognition of the unsubstantiated nature of these proceedings." He looked at Daniel directly. "Mr. Beaumont, I would encourage you to reflect carefully before bringing another action of this kind." Daniel did not respond. He was looking at the table. I stood up. I picked up my jacket from the back of the chair and put it on. I took my time with the second button, the way you do when you have somewhere to be, and no urgency about getting there. Robert Faulkner quietly returned the envelope to his case. I walked past the plaintiff's table. I did not stop. I did not slow down. My brother did not look up. I paused at the end of the row, just long enough to say it. "The furnace," I said. He looked up then, finally. "February, 3 years ago. When you told Mom you were stretched. That was me too." I did not wait for a response. I walked out through the heavy wooden doors and into the corridor of the Halifax Law Courts building. The light was the flat gray of a March afternoon in Nova Scotia, coming through tall windows that faced the street. Robert came out behind me and fell into step beside me without saying anything immediately. That is something I appreciate about him. He knows that some moments need room. At the elevator, he handed me my briefcase. "The CSE director's office called this morning," he said. "They said your judgment in the witness box was noted." "I was just answering questions," I said. The elevator opened. I stepped in. I thought about my mother's kitchen table. The folded piece of paper she had pressed into my hand. The way she had looked at me, steadily, not with pity, and not with pride exactly, but with the specific recognition of a woman who understood what it cost to do something important in a way that no one will ever see. She had known what I did. She had known what I gave. She had made sure, in the way she did everything, quietly and in advance, that it would not be taken from me. I looked at the enamel pin on my lapel, in the reflective surface of the elevator door. I straightened it slightly. For 7 years I had let my family draw conclusions from the outline of my life. Because the alternative was a conversation I was not permitted to have. I had sat across from my brother at holiday dinners, and listened to him describe me as a woman without purpose, without contribution, without the basic decency to show up. I had accepted it as the cost of the work. You make that choice when you take the job. You understand that the people closest to you will see the cover, not the work, and that correcting them is not an option. But there is a particular kind of silence that is not acceptance. It is patience. And patience, when it finally ends, does not announce itself. It simply becomes unnecessary. The elevator opened onto the lobby. I walked through the front doors and out into the cold Halifax afternoon. The harbor was visible at the end of the street, gray and flat and enormous. I stood on the courthouse steps for a moment and breathed in the salt air. My phone buzzed. A message from an Ottawa number I recognized. "Debrief 0700 Thursday. Good work today." I put the phone back in my pocket. I had not done anything extraordinary today. I had sat in a chair and told the truth, in the only way I was authorized to tell it, and I had let a sealed document do the rest. The victory did not feel like a victory. It felt like an accounting, a ledger finally brought into balance after years of entries that only I could see. I walked to my rental car and sat in the driver's seat for a moment before starting the engine. The courthouse was visible in the rearview mirror, its stone face impassive in the gray light. I thought about the first time I flew home after I started with the CSE. I was 25, and I had just completed my first full operational cycle. I had sat at my mother's table, and wanted more than anything to tell her what I had spent the last 8 months doing. The scale of it, the weight of it, the way it had changed how I understood the country I was living in. I couldn't. So I had helped her wash the dishes and driven my brother to hockey practice, and listened to my father's brother talk about municipal politics for an hour and a half, and I had felt, for the first time, what it means to carry something alone. 7 years later, I understood that carrying it alone was not a burden. It was the job. And the job mattered. It mattered in ways that could not be measured by what was visible at a family dinner, or in a probate filing, or in a courtroom in Halifax on a gray March afternoon. But it had mattered here too, today, in the specific and unambiguous language of $94,700 and a certified letter from a federal intelligence agency, in the exact and irrefutable terms of a judge who had read the document twice before he looked up. My mother had known. She had arranged it so that when the moment came, the truth would be available, even if I could not speak it myself. That was who she was. She planned for the silences. She protected the people who couldn't protect themselves in the usual ways. I started the car. I was not going to call Daniel. I was not going to send a message. There was nothing left to say that the court had not already said more precisely and with greater authority than I ever could. Whatever he did with this afternoon was his. Whatever came next in the estate process would go through the lawyers. I was done explaining myself to people who had already decided what I was. You cannot make someone know you if they have chosen not to. You can only keep doing the work. You can only keep showing up in the ways that are available to you, quietly, consistently, over years that no one is counting except you. And you can trust that the record exists, somewhere, even when no one can see it. Especially when no one can see it. If this story meant something to you, Please like and subscribe. And turn on notifications so you don't miss what comes next. And if you have ever been the one in your family who carried something in silence, drop a comment. You're not alone.